The Citizen Mike Show. News. Commentary. Interviews. Citizen Mike Show starts now.
Welcome to the Citizen Mike Show. Thanks for tuning in. We do appreciate it. My name is Mike Brodinski. On my right, the editor of the Record Journal, Ralph Tomaselli, and a special guest in the studio tonight, Republican Town Councilor Joe Marrone. Joe, thanks for coming on the set and running the gauntlet one more time.
Thanks for having me, and good evening, gentlemen.
Got a lot of stuff to talk about, but I want to lead off with maybe just a little update on the school renovation plan. Folks that read the Record Journal and watch this show sort of know what's going on. We can't recreate the wheel, you know, from the beginning because it's only an hour show. But the school board is considering spending a lot of money renovating up to 4 schools, possibly renovating as new. Numbers have been thrown out that, from that approach 110, 120 million, and there's construction cost increase that go on with time. It's a big deal if it ever gets off the ground. Joe, are you hearing from your constituents? Have you talked with any of your colleagues in private conversations? You know, what's the buzz?
Yeah, so I'm not hearing from any constituents.
Really?
So,
Okay.
I know the meetings have been fairly well attended. I know they've had a lot of people come to the mic.
Yeah.
I'm not getting any calls on it. Doesn't seem like a hot topic to people. I've talked to some of the board members privately and some of my colleagues about how they feel about the whole process. It started out as sort of my understanding of the conversation was that it started out as what can we do to get to one high school? How can we save money through one high school? And then it seems like it sort of shifted from the one high school concept now to what can we do, to move us forward. So I think the focus was started on, sort of modernization and minimalization of expenses, and now we've moved kind of to what's the next step.
Ralph, how do you figure that? I mean, social media is not hopping mad or jumping with joy. I mean, there is activity on social media, but not as much as I would have thought. Letters to the editor, I don't think I've seen one.
I haven't seen one.
It's a lot quieter than I thought. What do you make of that? Why is that true?
Good question, Mike.
Yeah, I know.
How do I explain why people aren't paying attention to something?
Yeah.
I only that, for whatever reason, I don't know.
Yeah.
I can't. I'm not going to try to come up with something.
Yeah, maybe, the obvious, I can only state the obvious. Not everyone, first of all, not everyone gets the Record Journal.
Right.
Not everyone is on social media. And so they have to pick it up. I think those in the education community probably know, and those not in the education community have some vague notion.
Well, there was a good turnout at that meeting.
Big turnout.
So,
two big meetings.
That clearly is a sign that people know about it. Now, I don't know what percentage of people at that meeting were teachers.
I think there's a lot of teachers, a lot of parents.
So it wasn't all teachers. So clearly there
and
are
some students
people who are engaged.
So, Joe,
certainly there's less of a sense of urgency with this plan than there was, say, in the past. My first year on the board is when they did the reconfiguration. Yeah. That was like coming, in the next school year, so it was a big deal. This is like 5 years off at the earliest, so maybe it's hard to generate excitement for something that's so far away.
So there was a meeting on Monday. I went to that meeting. I don't think much changed. I think before the meeting on Monday, you and I think when Aaron Corso was on set, introduced the notion there's really sort of the options are really already narrowed, politically speaking. I think one high school is unpopular. There's a lot of pushback from parents, teachers, and some kids. So even though it's going to one high school is still technically being on the table, I don't see the Board of Ed going in that direction because it's not popular, and you need community support for that. One middle school, there's no support for that. So what's left? 4 schools renovated to some degree, and the rest is how much money you want to throw at them. And eventually, it might come to Joe. how much you're going to spend on this.
Well, that, I guess, it all depends on what you're getting out of it. I mean, is enrollment, the anticipation is that enrollment will continue to slowly decline.
Yeah.
So it declined quite a bit, in the 2000s, and now it's sort of leveling off. So depending on where enrollment's going to go, how much do you want to spend renovating schools that you may not need at some point?
Yeah. Editorial comment on Monday's meeting. I got kind of a chuckle out of this. So a couple of weeks ago, at a big meeting at Lyman Hall Auditorium, Dr. Menzo sort of rejected, not sort of, he said the school administration is against the one middle school concept. Right. And it looked like everyone in the audience agreed with that position. And the way I read the faces and the body language of members of the Board of Education, they were in agreement too. So now we fast forward to this past Monday night. And poor Ray Ross is sitting up there as I watch the stage. I think he was on the far left. And he says something, makes a motion which a week ago everyone would have agreed with. Let's reject the one middle school concept. So now I'm being a little bit playful, a little bit of a rhetorical overreach, but just bear with me here. He says, let's pass a motion. I move to reject everything that has a one middle school solution in it. Board of Ed panics. They wiggle, they squirm, they don't like it. On 2 or 3 occasions, they tried to talk Ray Ross out of his motion to reject everything that would contain one middle school. And so finally, they talk him out of it, and they talk him into, well, let's just amend Alternative 6, which had one middle school, to include 2 middle schools, and that passed. But all through the night, Dr. Menzo and others were reminding those in the audience and the board, all options are on the table. You can craft any solution you want. This doesn't foreclose anything. You can bring up any idea you want to. So although it seems as if that motion locked out merging middle schools, right, it could be brought up again at any time. And I think I don't know why the board panicked when Ray Ross made his motion, but they certainly did.
Well, but hasn't there been, it seems like there's a pattern here, though. Anytime you try to narrow things.
Yes.
And it just keeps, I guess in the beginning when I first observed it, I thought, well, at that first meeting they were hesitant to narrow. But ever since then, it's just been constantly, it's so vague.
I think they're even more reluctant to narrow, make hard decisions. I think they've lost ground. They seem more confused and insecure than they were. Joe, we're going to get your reaction in 1 second, but I got another Ray Ross story for you, which kind of funny. So it was sort of understood at the beginning of this process that if there was one high school, it would be Lyman Hall because of VOAG and the size of the school and a lot of other considerations. That was the advice we got from the consultants. So again, Ray Ross asked the question, which seemed to state the obvious. Well, if there's going to be one high school, it would be Lyman Hall, right? Oh, another panic. Oh, no, we could do that. Yeah, that's... No, anything could be on the table. We could bus kids back and forth. No, we could do whatever you want to do. And then Dr. Menzo said, and in fact, if you want another neutral location, some plot of land, where you build a whole new school, we could even consider that. So they didn't narrow the options in my mind. Joe, your reaction to my observations on all this?
It's funny because I think you hit the nail on the head. I think there's a lack of focus to this whole process. I think the consultant was a good idea, and I think that now that they have options, but you're narrowing it down, you're not really making any changes. You're just doing renovations. So then, do you really need to have this sort of exercise to determine what you're looking for if you're just doing a building renovation?
Yeah. Let's change the subject. If you live on the east side of town, a big issue is the redevelopment of the Bristol-Myers property. If you don't live on the east side of town, it may be a big yawn. And you hear about it and you say, oh, good, maybe there's some more taxes coming in. But it's a very big project, and the files at Town Hall, the inland wetlands file, the planning and zoning file, I mean, it would fill this room. That's obviously exaggeration, but very complicated, a lot of moving parts. Joe, are you hearing from constituents about the Bristol-Myers redevelopment plan?
Yes, much more so than the school project, that's for sure.
Tell us, what do you hear?
I've had a couple of people approach me and say, I know you can't do anything, but you got to help us if you can, because they feel like they're in a
What do they
they're in a
want?
bind. So what they want is they want the Planning and Zoning Commission to not approve this project. The residents certainly
Yeah.
want them to not approve this project, and then people that live away from there, as you mentioned, don't really care either way.
Yeah. Again, those that read the Record Journal and watch the show sort of know where we are. It's a huge project that is proposed by the applicant. I think it's Calaire Company or something. Two big warehouses, truck docks, and certainly an increase in truck traffic. And the public hearing, I believe, is now closed, and it's in the hands of Planning and Zoning to meet in January and deliberate among themselves. It's a public meeting, but the public comment part is closed. And a decision I expect to be in January. The Record Journal had an editorial. Two. I remember one. I don't think I remember the other one.
First one was headlined BMS, Caution is the Byword.
Okay.
That was in November 28th. And then on December 16th, moving ahead with the BMS plan.
Well, the one that I read, and maybe I read both
Right.
in there, I'm conflating them both. The Record Journal was sort of mildly in favor of the plan as proposed.
I would say mildly. I think we would have preferred another campus-like setting up there, but that doesn't seem to be happening, and we have concerns especially about wells in the area, but could not find a reason to say don't move ahead with the BMS plan.
Joe, how big is the tax issue with you, and if you've talked to any of the counselors, how badly do you want the increased taxes?
Well, I think it's really about putting that land to good use and collecting tax on it. Obviously Bristol Myers was a big taxpayer, huge taxpayer, right? That was a big deal. So you're not going to replace them, but you want to see the land put to good use and not just it's in the industrial zone. You certainly want to see industrial properties generating tax revenue. So
when neighbors, your constituents, come up to you and say, we don't want this, what do you tell them?
Well, I'm sympathetic to their plight. I mean, their concerns primarily are noise and traffic, right? And so some of the traffic up a residential street, one of the I can't remember the name of the street, but one of the streets behind the property is where they intend to put a lot of the truck traffic, which doesn't seem to be really in the characteristic of that particular neighborhood. But at the same time, you live next to an industrial zone. I happen to live right off of 91. In the summer, when you have the windows open, you hear trucks all day long and all night long. So it's just it's something that you become accustomed to.
So I've got a slightly different angle on this, and it doesn't quite reach, my personally favor against it, or does the evidence as submitted obviously tend one way or the other. It's a slightly different approach, and it's a concern I have that the Planning and Zoning Commission and staff may, operative word, may, in my view, be misapplying or misinterpreting the zoning regulations and thereby steering the proceedings to an approval. And the question I'm raising is the standard to apply when a special permit is before the Planning and Zoning Commission. And the standard, one would think, would be very clear. It's in the regulations, and I'm going to put on my glasses and I'm going to take some excerpts of some of the relevant standards. So you would think, well, this would be very well understood, but I'm not so sure, and that's what worries me. So the zoning regulations has a section dealing with special permits, and one paragraph begins with a title, Criteria for Evaluating a Special Permit. This is a special permit request by the applicant because the site would draw too many vehicle trips, too many cars and trucks moving in and out, and too many is not the right word. It crosses a threshold. It crosses a threshold triggering an application for a special permit. That's why you need a special permit, the amount of traffic. So it says, when evaluating criteria for a special permit, the Commission shall consider and evaluate each and every application for a special permit by applying at a minimum the following criteria. There's a bunch of paragraphs. I'm going to pick a few. the appropriateness of location and use, the size and intensity of the proposed use or uses, and its or their effect on and compatibility with the adopted plan of development, the specific zone, and the neighborhood. Another paragraph says, well, you got to evaluate the special permit in view of the effect thereof on said neighborhood. Another paragraph says they should consider the obstruction of light or air, or the emission of noise, and it goes on, noise, and I'm going to circle back to noise, just bear with me for a minute. And then there's a separate paragraph, which is subparagraph H, the preservation of the character of the neighborhood. Well, that seems absolutely clear enough, but what seems to have supplanted some of this, again, it is I'm not really sure exactly how they're thinking, is the standard being applied for the level of noise that may be permitted. So it's my understanding during the last public meeting of the Planning and Zoning Commission, a noise report was offered. It was, I think the Planning and Zoning Commissioners were put in a position of having to go through a highly technical report sort of on the fly in public. Joe, you know all about that. When something is dropped on you in the last minute, it's sort of tough to fine-tooth comb it and give it all the, due deliberation you need and ask all the relevant questions. But my review of this indicates the state of the evidence is as follows. There, around the site, noise is going to be emitted that reaches the neighborhoods through various locations around the site to various spots in the neighborhoods. Noise will reach those neighborhoods, and the level is measured. It's a sort of a projection, because the site hasn't been built yet, of 30, 40, in some cases 50 decibels reaching from the site into the neighborhoods. And the expert that submitted this seemed to believe that the standard to be applied was the town council's noise ordinance. They seem to think that, and there's some comments by one commissioner referring to the noise ordinance, and I believe during one of the meetings when noise ordinance was mentioned, I wasn't at that meeting, but on the video, it seemed like the audience groaned and laughed and sarcastically chuckled because they know all about the ineffectiveness of the noise ordinance, right? I mean, we've talked about that with Thurston and Oakdale. So if someone is suggesting your protection is the noise ordinance, you say, oh boy, I just been screwed. That's it. Really? Seriously? Right. And so what concerns me is, wait, I just read a regulation, and the noise ordinance wasn't in it. They didn't incorporate by reference a noise ordinance. There could be two different standards. Something could seriously impair the character of the neighborhood and still comply with the noise ordinance. Is the Planning and Zoning Commission substituting the noise ordinance as the functional equivalent of character of the neighborhood? And I am worried about that because I don't think the noise ordinance was ever intended to allow someone to increase the noisiness, into the neighborhood. And I think the current law is that the character of the neighborhood, when it's in the regulations as this is, preservation of the character of the neighborhood is something apart and different from the noise ordinance, and the Planning and Zoning Commission, in my view, needs to take that noise report and sort of figure out what that means to the neighborhood. What do these decibels mean, and will it impair the character of the neighborhood? And if they feel it does, but they're going to prove it anyway, fine. If they say, nah, what's 30, 40, or 50 decibels, that's the way they go too. But it's the uncertainty as the standard that bothers me immensely. Joe, I just unloaded a lot on you, but your thoughts on my thoughts.
Well, let's back up. So we led with the preserving the character of the neighborhood, which makes good sense. But I guess when you're in the industrial zone, is the neighborhood the industrial zone, or is it the residential neighbors that are adjacent to the industrial zone?
Well, I think that's a very important. I think that's a very important question. What is the neighborhood, and make for a good appeal. Maybe the court ought to decide that. And I think the neighborhood may be whatever the Planning and Zoning Commission says it is, but the cases, and the last one being a 2017 appellate division case, seems to suggest that the neighborhood are the houses impacted by the use. That seems to be, but that's a very good and important question. And if you say, well, the neighborhood is the commercial zone, that's the neighborhood, then the sky is the limit for noise, fumes, traffic, because the residential part not being in the neighborhood, totally irrelevant. So what else I'm making an argument now, but as I say, it's good grounds for an appeal. What is the neighborhood? How does that work?
Well, agree. And you've seen this with the Thurston's thing. You've also seen it with folks that live close to the airport. Not so much in town, but like the East Haven residents that live near Tweed Airport. You have this same argument all the time: is what's the noise relative to where they live?
Yeah. So just referring a little bit to this noise report, it says major sources of noise are trucks entering and leaving the property, over-the-road trucks dropping and removing trailers, and trailers being maneuvered by a switcher tractor. I don't know what that is. Also among the primary noise sources studied is sound produced by backup alarms and trailer disconnect impacts. And it may be that backup alarms are not even covered by any ordinance. So I'm not sure, but the question needs to be asked, can you have a backup alarm that is so loud that every reasonable person would agree it impairs the character of the neighborhood, and the planning and zoning is going to look the other way and say it's irrelevant because it's excluded under some statute that has nothing to do with the character of the neighborhood? Ralph, your thoughts?
Well, it's funny you bring up appeal, and
I wasn't the first one to bring it up.
No,
the neighbors are talking.
Right. Well, as you were reading through that document, I mean, there's already been one lawsuit filed, and I thought that the thought crossed my mind that no matter, if the Planning Commission approves this, that the neighborhood is likely to file suit, and I just wonder what that means for the time frame of the project.
I really...
Not that
I can't answer that.
No, I know. I think
it has to work its way through.
Right.
And that might take a year or two.
Right. That's I think what I'm suspecting. No matter what the Planning Commission, even if the Planning Commission approves this in January, we could be in for a year or two of court.
We're going to take this up on other shows because I think we're going to see a decision middle of January.
Right.
And so we'll have Citizen Mike shows, and we can comment and maybe get some clips at the right time and see how they dealt with noise, And there's certainly a lot of other issues in play, and I didn't mean to, I wasn't ignoring them or rejecting them, but it's only an hour show. We don't have an opportunity to go over all the other issues that are being raised and maybe dealt with by the town. So on Sunday, December 16, on the front page, below the fold, was a story dealing with Craig Fishbein.
Way below the fold.
Yeah, way below. You're
bottom.
Right. Yeah, continued on page, I don't know what,
way down at the bottom.
In Etherland. It's a story about Craig Fishbein, and the general impression, if you read it quick, was, I don't know, Craig is raising some technical issue about, some labor contract or something or other, and then everyone piled on against Craig because Craig was, Craig, and so everyone jumped on the bandwagon, didn't like what he said, and you had such august authorities as Janice Small, the Corporation Counsel, Mayor Dickinson, Vinnie Cervoni, Vinnie Testa, Jason Zandri, and of course, at that particular meeting, which is the December 10 meeting that the story was reporting on, Sal Menzo was at the table trying to fend off Craig Fishbein. So just based on a popularity contest, and the headline, Fishbein's stance on union contracts is questioned. You figure Craig is obviously dead wrong. No one agrees with him, and there are 4 or 5 or 6 people that disagree with him. He's got to be wrong, right?
I did not think Craig was wrong.
Well, but I'm reading the story
right,
here.
Okay, that's fine. I'm just saying. Right. I think Craig usually chooses his words very carefully.
Yeah.
But go ahead. I'm sorry.
Well, this is sort of context, and I got to explain in a little more detail what the issue Craig was trying to raise. And these are my words now, not his. I'm not. I don't have a transcript of what he said. But there was they had a labor agreement in front of them, and the council was to pass judgment on either by approving it, rejecting it, or doing nothing, which would result in approval of that labor contract. And Joe, you were I think at a meeting on November 27 that had a similar issue that was raised.
Correct.
Yeah. And what was in play was some language in the contract, which if you read it, it says, as a condition of your employment, you got to join a union and pay union dues.
Right.
Yeah, that's what the contract says. And Craig was raising, I don't know, some constitutional issue or something that made it appear that was illegal, and no one saw any merit to anything he said. Change the chapter. I want to change the focus. I just want to pull out the United States Supreme Court decision.
Okay.
Can I do that?
Absolutely.
Very gingerly, because I don't want to step on anyone's toes or hurt anyone's feelings here. I don't want to do that. So this was an opinion that came out this summer, and it was an opinion called Janus, Janus, and it comes out of Illinois. It's only an hour show. I can't go over the facts of the case, but it's very similar to a scenario that confronted Joe Marrone and the town council. And the opinion of the court, just a couple sentences that I want to talk about. The Supreme Court of the United States says, as a matter of constitutional law, neither an agency fee nor any other payment to the union may be deducted from a non-member's wages, nor may any other attempt be made to collect such a payment unless the employee affirmatively consents to pay. Was that clear? Did I read it okay?
Absolutely.
Okay. Bruce, I think we may have a JPEG to set up. This was some language that was confronting the council both on the 27th of November and December 10. Let's put that up. So on December 10, and that's the meeting that triggered the story, the contract language said in one of the paragraphs, all employees within the bargaining unit shall become and remain members of the union or pay a service fee equal to union dues as a condition of continuing employment not later than 30 days after their date of hire, right? Bruce, let's take that down, but I'm going to ask you to put it up in just a couple minutes. So we read that, we understood it. Become an employee, got to join a union, and you got to pay union dues. Do I need to go back to the Supreme Court case?
No.
Okay, we understood that.
Right.
Clearly, there's no doubt, as Jim Hutt on the 27th, the personnel director, and Sal Menzo on the 10th eventually conceded that the provision in the contract was inconsistent with the United States Constitution, someone's First Amendment rights. Yet, we have the Board of Education, Town of Wallingford, and the Town Council, and the executive branch, Janice Mull and even Mayor Dickinson, saying, don't worry about it. Don't worry about that little old First Amendment. We can put this in the contract anyway. Joe, why did that happen? Why bend over backwards to put something in a contract, to approve a contract that clearly and obviously, there's no doubt about it, is inconsistent with the First Amendment, violates the First Amendment?
Well, clearly inconsistent with the First Amendment. No question about that.
Yep.
So
and violates the Constitution.
Yes. So why put it in the contract at all? And I think the reason is because when you're negotiating with the public sector unions, this isn't like negotiation between two lawyers or two partners. If any issue that the union perceives as having been, I've been in many negotiations with the Board of Ed. So anything that they conceive as a concession on their part, they're looking for something on the other side. So for the town, why is it worth spending the time or the energy to try to eliminate the illegal language when it's probably not legally enforceable anyway? So from the town side, you're not going to give up anything to get that language out. So I think you just let it stay, and then if it becomes an issue you have to adjudicate, then you're on pretty firm grounds. So, Ralph, why not just do the right thing? I mean, what I heard, and Joe is going to have 2 or 3 chances to reply to me here, but what I heard was, we know we're tricking naive prospective employees into believing they have to pay union dues by putting this in. We know we're tricking them. Or attempting. You don't think so?
Yeah. No,
why is that language in there?
Yeah,
then?
right.
I mean,
I wasn't. No.
Yeah.
Okay.
So we know we're tricking them. We know by agreeing to this contract, we're conspiring to do something inconsistent with the First Amendment. why not do the right thing and say to the unions, this language violates the First Amendment. It's coming out. If you want to negotiate, we can. There will be an impasse. And if you want to take it to arbitration, you do that, because this is an ongoing issue. And we're not going to be a party to a contract that tricks unsuspecting employees into believing they got to pay union dues, creating obstacles to getting a refund, or making them believe they have to join a union. Joe, why not just do the right thing and stand up to the contract, stand up to the union? That's what negotiation is, and say, hey, we're not doing this.
'Cause I don't think this is an issue worth going to arbitration over. I think if the town wanted to, there's other ways you could address it with employees to make sure that everyone's aware of what their rights are. You could send everyone a letter saying that this part violates your First Amendment rights. Here are your rights. And not that the town is going to do that, but that's what the action they could take. So
Wow.
I think when you're at the bargaining table, it's a whole different ballgame, because it's, any change in language. So by way of example, we had a particular contract where the board wanted to provide uniforms for a certain employee group. And many of the people in this bargaining unit went out and bought their own clothes with their names on them and stuff, so that they had sort of their own de facto uniform. When the board offered it, they felt like that was something that they were giving up, the right to choose their own stuff, and so they wanted something on the other side. So to someone outside the negotiation, you would say this is a benefit, right? Because we're giving you clothes to
Wait a
wear to
minute,
work.
I don't give a lick about the union. I don't give a hoot about the union.
Okay.
I don't give a hoot about them. We're talking about First Amendment rights of an individual
Right.
who may be trying to be getting a job, in this part of town, government.
Mm-hmm.
And that individual, obviously the intent is to trick that individual because the union wants it.
Mm-hmm.
There's no other purpose.
Agree.
And so the town is saying, we're going to help you trick this employee. We think that's the right thing because we may be getting some material benefit somewhere else down the line. Isn't that your position?
So I think what you're saying is,
Yeah.
you're saying arbitrate it, right? Because that's the way to get out of the
I'm not
contract.
saying arbitrate
Because the
it.
union's not going to
The
give it.
unions would never arbitrate.
But we would have to concede something to get it. So
You
why
think so? You
why
think
should
so?
I spend taxpayer money to get something that only exists on paper anyway?
Because it's the right thing to do. Bruce, let's put that JPEG back up, and we're going to go to a video right after that. So there were two contracts in play, one on the 27th of November and one on the 10th of December. And the one on the 27th of November had to do with the AFSCME. An agency fee payer may apply to the AFSCME International Union for a rebate in accordance with the union procedures. And of course, we know that the Supreme Court has said, nor may any attempt be made to collect such a payment. That's First Amendment right, and you violate the right if you make an attempt, unless the employee affirmatively consents. So on the 27th, it said, again, to keep that up, Bruce, all employees within the bargaining unit shall become and remain members of the union or pay a service fee equal to union dues as a condition of continuing employment, not later than 30 days after their date of hire. And let's take that down, Bruce, and we'll see how the personnel director for the town of Wallingford justified or explained that provision. Let's roll that video. 3, 2, 1, go.
And essentially what the town was looking to do was to strike the agency fee language. However, the unions in the Board of Ed as well as the town had their own proposals as well. And so it was decided that rather than, haggle over the language that's unenforceable, if the contract had a savings clause, we would fall upon that.
So there you go. I mean, he says it's unenforceable. Sal Menzo on December 10, after an excruciating dialogue with Craig Fishbein, in the end conceded the same thing. He said it's inconsistent with the statute. I think he meant the Constitution. So everyone knows it's unenforceable except the naive people that come into the union. And I get your argument. I get your argument that's okay to play fast and loose.
So argument's not to play fast and loose. The
Okay.
Supreme Court said that you need to have affirmative consent to
Yeah.
take the dues.
Yeah, you
That's your opportunity to tell people about their rights. So I don't know.
Say that again?
That's your opportunity to tell folks about their rights, because they're going to have to sign something or agree in some way to have this taken out of their paycheck.
Yeah. Yeah.
Well, I don't know if it has anything directly to do with this, but there also is a grievance involving this issue.
Yeah.
Right, where two employees apparently at first said they wanted to opt out of the union, and then the union is now claiming that they asked back in. And do I have that right?
I'm not sure, but I think the way it started is that the employees wanted to opt out and
Right.
get their money back, and there are
Right.
obstacles put in their way.
Okay.
And if the town is in any way participating in creating obstacles for these people to get their money back, I think the town is in hot water for intentionally violating someone's First Amendment rights. That's a serious matter. There's serious liability for participating in a scheme to deprive someone of their First Amendment rights. Now, there have been quotes around, we would never do anything illegal, we'll give them their money back if we, but this is the first step into some litigation-prone stuff, and you put your finger on one area of litigation,
right,
the labor board.
And I think
Yeah.
the thing that surprised me about the mayor's comments and the personnel director's comments was, in the grievance issue, the town agreed not to collect union dues out of the workers' salaries.
That's how I understand the story.
Right.
Yeah.
And so there I felt like the town was sympathetic.
But look what happened to them.
Right.
Aren't they ensnared in litigation?
But then now the mayor is arguing, it seems like they're arguing the other way.
Yeah. I can't
And I'm
assume the
simplifying.
mantle of the mayor's defense.
Okay.
I got some quotes from the
No, I'm
paper.
not defending the mayor.
I got some quotes from the paper, and which, taken together, make it appear like Craig Fishbein is absolutely wrong when he's absolutely right.
Okay.
And Craig Fishbein, all he was saying was, it violates First Amendment, it's unenforceable, don't you agree? And it was excruciating to get. Everyone should have said, absolutely it's unenforceable. Absolutely is inconsistent with the First Amendment. We're doing it anyway because we think we get a financial advantage. Right? That's the justification. So Mayor Dickinson said, this is in the paper, the language issue will be resolved, but it'll take time. Well, that's the mayor's problem. The law is in transition due to a recent court decision, he said. Does the Supreme Court case sound like it's in transition? The law's been clear as of the summer 2018. So, sorry, Mayor, it's not in transition. He said, we have obligations to negotiate with another party. Yeah, so here's how that goes. The union says, I want this illegal, unenforceable language that tricks employees. And the town says, we can talk about it, but we're going to reach an impasse. You're not getting it. That's how that works. And that's how you solve it. You go through arbitration, you defend the First Amendment, and you do the right thing all at the same time.
But how much taxpayer money are you willing to
I
put
don't
into?
care. It's the First Amendment. It's the First Amendment, and it's not that much money to do that. Why? Because the labor board is going to look at that and says, we've read the Constitution too, Town of Wallingford, and we agree with you. And it's not going to be a long and involved. Sometimes you have to fight for the right thing, and sometimes you just cave in for the wrong thing, and that's how I see it going. Anyway, Janice Small echoed Dickinson's comments. We're going to comply with the law. Yeah, that's not the issue. I think what Janice is saying, we agree that the clause is unenforceable. We're not going to withhold anyone's money against, if they don't give consent. I think that's what she's saying. Then she says, and it is scribed down here for your reader, there's some flux with the full parameters of the Janice decision. Minnie Cervoni weighed in, talked about the savings clause, which is irrelevant. Vinny Testa weighed in. He thought it was unfair for Craig to raise it. I think it's unfair for Vinny Testa to comment on something involving the Board of Education. He's employed by the Board of Education. So, and we've talked to Vinny about this before on set. If there's something involving Sal Menzo or Roxanne McKay, when Vinny makes a comment in support of them, I just moot my computer and I don't pay no never mind. Joe, final thoughts before we change subjects?
Final thoughts. Craig is right. Craig's other option would have been to make a motion to reject the contract.
Yeah.
With the illegal language, which he also chose not to do.
Yeah, you would have voted.
If he made a motion to reject the contract, I probably would have voted with him.
Would you?
I would have. Because despite the fact that I think that the town puts them in a worse financial position, you have to buck back sometime. I don't think what the town did was wrong. I mean, I guess I'm trying right now. I'm playing both sides of the fence, which I suppose is a.
I'm just surprised. I don't know, but go ahead. Yeah, go ahead.
But I don't think you would have had the votes to pass the rejection anyhow.
Yeah. So Jim Hutt, actually, I'm going to spend another 30 seconds on this. On that video that we played, Jim Hutt said the town decided that rather than haggle, over the language that's unenforceable, they would rely on something called the savings clause. Haggling is another word for negotiations. So they decided not to negotiate that. Let's talk about money. Lots of it. Joe has been outspoken in the way the town has done some budgeting. He's had some thoughts on how maybe we could do some things better, and so we wanted to bring this up while Joe was on set, and we got 15 minutes to do that. I got some context for you, then I'm going to turn it over to Joe.
Okay.
The town has something called a capital non-recurring fund, and it's the money that goes in there is basically money from the electric division. It's by ordinance, and using rounded numbers, it's about $2 million a year that goes from the electric division into the town account, into the capital non-recurring fund for big ticket items, roads, bridges, sidewalks, things like that. Any other town would die to have an electric division pumping $2 million a year, in a capital non-recurring, and so I pulled out the computer runs that the town generated just a week ago. Well, it's dated December 12, to see what's might be kicking around the capital non-recurring fund. And I find, whoa, 2012, money appropriated in 2012. There's some money still in there from Wallace Ave Construction. That's the way to get into the Wood and Kaplan property. There's still $40,000 in there. Going to 2012, there's still money appropriated in 2012 into the capital non-recurring fund, right? I hope I'm not getting ahead of myself. There's still $79,000 in that. Wood and Kaplan parking lot dates back to 2013. There's $7,600 in that. Hall Avenue streetscape, that's the gift that keeps on giving. That's like $1 million since the time I was born that's stuck in there, but that's another show. We're getting a little more current now. Just 3 years ago, money appropriated in 2015 has got it's got much more than that. Townwide paving program, I'm rounding now, $500,000. Athletic field improvements, $243,000 left over. In 2016, Northfield Road Bridge is still $400,000 in that account. Athletic fields, recreation, still $40,000 in that account, and so on, right? Joe, it just seems that either there's something I don't understand. That's one alternative. We're appropriating money faster than Henry can get it spent. Maybe, I guess I'll stop there. But why is this happening, and what's the solution? Or is this reasonable and necessary and should be expected?
No, I think this is the second one that you mentioned. I think we appropriate more money than Henry can spend. And I think that every year at budget time, we talk about what roads we're going to pave and the number of roads that are going to get paved. And we set some very aggressive targets. And I'm not sure that we ever actually achieve the goals. I mean, you've listed some things there that obviously some work that didn't get done. So I guess the question for me is what happens to all this money that's like right now it's sitting in an account waiting to be spent or potentially never to be spent, or for them to close out a project and return that money to the general fund. So that's just something that I had highlighted before that I thought was sort of broken in our budgeting process, which is we have this money. The mayor decides where it's going to go, or the mayor and the administration decides where it's going to go, and then the council can either approve it up or down.
Do you have an approach for this coming budget year as to how to address this,
what I brought
or
up
how to raise it?
what I brought up several times, and it really hasn't gotten any traction, but some towns have a fund that's for capital improvements only, that's managed by maybe a commission that's not the council or the mayor, and maybe they make recommendations. So rather than separating school projects and town projects, perhaps you put all the projects in one bucket, and you let a commission or the town council or whomever decide, what the appropriate place is for these projects. I like the idea of a commission because this could be someone that's not the council that maybe makes recommendations to the council. They have an idea of what the projects are, what's important, in each division. So maybe community pool is something that we're passionate about. I'm not particularly passionate about it, but I know certain councilors are. If that's where we really think we should spend the money, maybe we divert the money away from, blinds at Dag Hammarskjöld to community pool or something like that. And so I think that these are townwide decisions and not necessarily divisions within the individual departments.
Ralph, you sort of heard the background that I read off in Joe's explanation, but you could cover other towns too. Is the data that I read off merely inflammatory and is of really no consequence? And given the size of the town and everything else, you would expect to have money kicking around capital non-recurring, being non-productive money for 5-6 years. I mean, that's not a big deal. Do you think I'm overstating it, or just
No,
your reaction?
I can only let you know that Meriden went through a similar situation where in a really tight budget year, they went through, they took stock in all these all this capital non-recurring money that was just sitting there, and targeted it all to close the operating deficit. So, but the notion of targeting, I've also seen it where projects have come up and a town will say, well, no, it's not going to cost the taxpayer $3 million. We have $2 million that we appropriated already that we haven't spent. We'll apply that there.
Yeah, so let me get a fixed example so I can get back to Joe. In 2015, we appropriated $1.1 million, rounding numbers, for a townwide paving program in 2015. There's $500,000 left in that. I wouldn't mind if I was taxed that $1 million and we spent it so the roads would be improved.
Good
What
point.
I am uncomfortable with, they took my money and didn't deliver my package, like from Amazon or something. I paid for it way in advance, and I'm not getting the benefit. How more specifically, Joe, can that be addressed somehow? Can it be raised? Do you have any allies? I mean,
Well, yeah, and my thought on having a separate commission would be that then their job, an ongoing commission that would then look at things like what are projects that are not closed out. So the $500,000 on road construction, can you reasonably add that to whatever money we're going to appropriate this year and get more roads done? Or is it beyond the scope of Public Works to get it all done? Maybe you put that money somewhere else.
Would you be in favor of outsourcing if that's what it took to get it done?
I'm 100% in favor of outsourcing in any circumstance because I think the private sector can almost always do it cheaper.
Yeah.
Well, I think it's good that we're talking about how to deal with this, but doesn't anything start with the mayor's office?
Yeah, he'd have to.
Right.
He'd have to go along. Yeah.
And I just am not seeing that.
Yeah. Let's change the subject. Ralph, you always like to talk about this.
What?
And I never let you do it because,
What?
This is a polite show.
Well,
You always like to talk about sex and marijuana.
yeah.
You always do. And I said,
I started blushing before
no,
it even came up.
you're such a button-down guy.
I just
You're such a
am
button-down
not used
guy.
to talking about it on TV.
So the Hartford Courant had a recent article. The title was "Study Looks at Sex and Marijuana Laws," and I think, the lead sentence: the legalization of medical marijuana leads to a rise in birth rates because drug use leads to more risky behavior and more sex among users, according to researchers at UConn. And you, as I recall, when we discussed political platforms for the election, weren't you in favor of legalizing recreational marijuana?
I was.
You see where you were.
I was.
Well, see where this leads you now.
Right.
You knew this.
Right.
You had this in mind. The rising birth rate comes from people having more sex and some suggestion that people are more risk takers and are having unprotected sex, said this researcher who published a paper, and so on and so forth. So, Joe, legalization of marijuana is going to come up again and again and again and again. Where do you stand on that? Now that I've laid the background for that, where do you stand on?
Well, when it comes to social issues, I tend to skew more libertarian. So I guess I like the idea of letting people to sort of make their own choices as far as how they want to conduct themselves. And if you want to, I certainly wouldn't advocate my kids to use marijuana. But if you choose to do it, in the privacy of your home and it doesn't affect me, then I don't really care so much. However,
you read the consequences.
However, now there's a consequence, right, that affects society, and I don't think it's good. I frankly don't think it's good for you. So. It's funny, we're waging a war right now on cigarettes, right? But suddenly, because pot generates more revenue for the states, all that cigarette money now is in decline, so it's a lot of tax revenue that the states aren't getting. So now we're legalizing pot everywhere as a way to make up some of that revenue. So I think that the states are going into this for the wrong reason, and perhaps putting people in situations that's ultimately going to cost the states more money anyway.
Well, I think more sex is a very good reason. Now that you know the salacious background behind this, are you changing your mind? And
No, and I hate
okay.
to bring up a serious side to this.
Darn, this was not supposed to be a serious.
I will just. I think one of the reasons I come at that I'm in favor of legalizing recreational marijuana is I think that overall we're just not able to enforce drug laws in this country. I mean,
Agreed.
we could spend a whole show, a series of shows on how drug laws are enforced in this country, and I can only tell you that I live in Wallingford and I work in Meriden, and the vast difference the way drug laws are enforced in the center part of Meriden versus this. So that's my problem.
I want to change the subject, and we got a couple of minutes to talk about local politics. We got municipal elections coming up in 2019. People never stop campaigning. You know, candidates in office will never stop campaigning. Everything is on the campaign trail. But it occurred to me that an issue, either a positive issue or a negative issue for this time around, November 2019, would be which candidates, council and Board of Ed, are in favor of a $125 million school renovation plan. Who are the $125 million candidates, and do they win on that? You know, invest in schools and invest in education, it's for the kids. Do they win on that, or do they lose on that? And I want you to go first on this, Ralph. Does the Record Journal put their feet to the fire, and ask real specific questions, and don't get off the quote until you get a real answer? Are you a $125 million candidate for the Board of Ed or Council as they run, you know, towards the November 6th election? Or do you let them wiggle out?
Well, I don't think there's going to be a $125 million candidate.
Oh.
I don't think that there, I just don't see.
Even on the Board of Ed? Because I see 7 of them.
Well, right, and when I say,
I do.
I would say if I was, let me rephrase.
Yeah.
If I was advising somebody to run,
yeah,
I'm not sure $125 million would be the moniker that I would.
150.
150
would be the better.
No, I really don't. I don't think this is going to be a good year.
Yeah, but you know, opposing candidates could paint a Board of Ed candidate. If they're challengers, they could say, you're a $150 million Board of Ed candidate.
Right.
You know, but that they have to be drawn out as to where they stand, and counselors too. We have Jason Zandri, who's already made a quote in the Record Journal. I think it was a front page story.
Right.
Counselors react to Board of Ed, and Jason said whatever the board wants. He's pretty much, if the board comes down, you know, with cost increases given the amount of time and mission creep. Ends up to be 125, 150. You know, that's one council vote. How do you see it, Joe?
In terms of the election, I think whether or not people are $125 million candidates is how people think the election is going to go. I think with, you know, you sort of saw the blue wave or the blue trickle this year.
Yeah.
I feel like in the past we've seen a red sort of backlash the following year, and with a far left governor, you might see a situation where voters in town are angry about taxes and such. So it may not be the best year for a $125 million candidate.
So they delay it till after the election. They stay away from it.
I think you delay it till after the election. I think you try not to make it an election issue. I think if you're pro $125 million development, and I think they've already bought some time because they said, you know, we may not break ground on this for 5 years. So you know, there's plenty of built-in time.
So no hard decisions by the Board of Ed until after the November elections?
I think the Board of Ed maybe comes up with a recommendation, but I don't think that the council votes on it by.
But if they vote for their recommendation, they're painted with their recommendation.
Well, that's true. You know, and then you come down to how many, in a municipal election, how many people look at what the Board of Ed candidates actually voted for.
So maybe we'll just let them stew in their own juices for a while. Okay. We've run out of time. Joe Marrone, thanks for coming on the Citizen Mike Show.
It's always a pleasure. Thank you.
It's always a pleasure having you. And we are off for the next 2 weeks.
Yeah,
we'll be back. The January 9, I think, is the first show. Have a happy holidays, everyone, and Merry Christmas and season greetings to everyone, and to Joe and to you, Ralph.
Thank you.
Same to you. Thank you.
Good night, everyone.
Good night.